is the Family Medical Leave Act. This is a federal law. Again, most states would have a similar kind of law, but for the U.S., it involves companies with 50 or more employees, and they could be in multiple sites as long as they're within 75 miles of one another. So employees who work roughly a little more than half-time, 1,250 hours a year, they are covered during the previous 12 months. So you have a brand new employee, they're not going to be covered under FMLA. But once they've worked with you for 12 months, for 1,250 hours, then they are covered. There is no requirement at this point to pay employees while they're on FMLA. However, if you have vacation time or PTO or sick leave, employees normally can use that time for FMLA. But FMLA does not require you pay people. But it does require that you give people time off. Typically, it's 12 weeks in a year. There's different ways of counting that year, but it's for your own illness or for your own pregnancy or for the care of other immediate family members, service members, your children, your spouse or partner. Well, the partner thing may be a question too, but is it a legal partner? Now, that 12 weeks many times is continuous, but in other cases it could be intermittent. Maybe you need intermittent care for something. Chemotherapy might be an example. I need to take every Wednesday afternoon off for the next period of time. That would be an intermittent leave of absence, and that would still be covered with FMLA. But so you give them this time off, and the deal is that we protect their job. That we have to restore them to a same or equivalent job. It may not be exactly the same job, because maybe you needed to fill that with somebody else, but it needs to be equivalent. This would be another case where you want to watch out for retaliation, that all of a sudden, you say, this is the same job, but it was a different work shift that was less desirable. That kind of thing might be a concern. So some things to think about with the Family Medical Leave Act. The first is you need to determine whether they're eligible. Just because someone says that they need time off doesn't mean that they really do. So you have a right to get a medical certification. You have to go to their physician or their care provider, and there's forms for all of these things, and to determine that they really do need the time off. Okay. Then we have to determine and notify the employee, this designated notice, that we are either giving them the time or we're not. Of course, legally, if they're eligible and it's qualifying, we have to give it to them. Make sure, again, there's more paperwork that goes along with this, and then we need to track it. Sometimes that's pretty easy if it's continuous. They've gone for 12 weeks, and we know what that is. If it's intermittent, it could be much more complicated. Or if somebody has multiple medical issues throughout the year, maybe one needs 2 weeks off, another one needs 1 week off, another one needs 3 weeks off. You need to keep track of this utilization for that 12-month period. And I already mentioned returning to equivalent job. So there's a handout here too that hopefully will help you. Gets kind of on the complicated side. And this is where it gets really complicated, because these are 3 laws that all could come into play. Just imagine someone has an illness, they qualify for FMLA, and with that, it's 50 or more employees for the Department of Labor. That's a federal law, not the state one. But also, let's just say that this is tied to a disability, which we're going to talk about next. So they have a medical issue, they also have a disability. Well, the ADA applies to employers with 15 or more employees. So even if you're a smaller employee, there may be issues that get tied into this. You may not be required to cover FMLA, but you are required to cover ADA. And then say it's a work-related injury, workers' compensation. Typically that is a state law. Usually it covers all employees, but it could be medical as well. So it's possible that this medical need ties into all of these laws, and it can get really complicated. And we want to do it the right way. More often than not, you might need to get someone, a labor attorney or employment attorney or consultant, to help you work through it to make sure you do it right. And we all want to do it right, but it is not necessarily easy. Okay, mentioned earlier about the Americans with Disabilities Act, Amendment Act. And so the idea here, this is another protected class, that we cannot discriminate against someone who can do a job but has a disability, with or without an accommodation. I'm going to talk about that. So the deal is, if someone can do the essential functions of the job, the main parts of the job, but they have a disability, then we need to not discriminate against them. Okay, what does this mean? What is a disability? Well, it's a physical or mental impairment that keeps people from being able to do bodily things. I'll talk about what a major life activity is in just a second. So if they can't do if you can't do certain physical kinds of things, or if there's a record of disability. So sometimes a person may have had a disability in the past, so there's a record of it, but it's not really a problem anymore. It still could be considered a disability, and we may need to make an accommodation. The other is that I think you have a disability even though you don't. But if I'm regarding you and treating you as if you do, then the law applies to you as well. In most cases, it's if someone actually has a disability that impairs them so they can't do these major life activities. Well, what is a major life activity? It's basically all the things that have to do with your body and your life. So, whether you can see, you can walk, whether you can lift, whether your brain will work, you can think, concentrate, hear things, all of these different functions of your body. It's very broad. And if you have a physical situation or a mental situation, because it includes cognitive thinking, dementia, things like that, if that gets in the way, then you're considered to have a disability.